This video extends the lesson, Day 7, Warsaw, Privacy Notice, and contains an in-depth comment of the Articles 12 and 13 of the GDPR. Please find in the description below references for the GDPR course. Information in line with these requirements must be transmitted in writing or by any other means. The chosen mean depends on the targeted audience, and it includes electronic forms such as applications or websites. Recital 58. If adapted to the situation, it might be provided through cartoons, infographics, or flowcharts, guidelines on transparency. Another means of providing the information is through a secure self-service system that gives the individual access to her/his data. Recital 63. Information can even be communicated verbally if requested so, provided that the data subject proves her/his identity by other means. European regulation also addresses the form and structure of the information. Privacy-related information must be differentiated from other legal details such as the general terms of use, guidelines on transparency. It can be separated into different logic paragraphs, each one of them preceded with a heading stating its actual content. It is sometimes referred to as the layered approach in European documentation. The use of headings, bullets, or indents to logically structure the document, whether it is a privacy notice or an answer to a request, is a pragmatic answer to a legal obligation. Controllers should facilitate access to information. They should maintain mechanisms, Recital 59, through which data subjects can exercise their rights. Articles 15 to 22, receive information, where personal data are collected from them. Article 13, or obtained from third parties. Article 14, or be informed of data breaches. Article 34. The information obligation extends to situations where the exchange of data takes place between two administrative bodies. Q. Smaranda bara e Presidentel KCI Nacional do Asigari de Sanitate. Facilitating access to information can be done by resorting to a standard form. It could ease the formulation of a request by the data subject and the controller's work to receive a structured message with the needed information to process the request. It has to be noted that the form's use cannot be made mandatory, as any other forms of submissions are valid, orally, by email, through a letter, etc. Controllers must act quickly on data subjects' requests. Article 12(3) imposes severe delays in providing the information requested or informing data subjects on action taken upon their request. The general rule is that controllers should proceed without undue delay, but the GDPR does not define the expression delay. Without undue delay must be understood as soon as possible, but at least within a calendar month after receiving the request. Exceptionally, the period may be extended by 2 further months. It is possible only if the request is complex or there are many requests to be answered simultaneously. The controller in such an event has to inform the data subject within the initial period of 1 month of her/his intention of prolonging the delay. The computation of the delay starts when the request is received or, if applicable, after getting the confirmation of the person's identity requesting the information or the payment of the fee. There are circumstances where controllers may refuse to answer a request. Recital 59. If they deny the request, they have to inform the data subject in the same delays mentioned above why they refuse to act. They must also notify the data subject of the possibility of lodging a complaint with a supervisory authority or seeking a judicial remedy. A request can be denied if it manifestly unfounded or excessive. Article 12(5). It can be the case, for example, when a data subject made repetitive requests over a short period. It can also happen if the person is making a request simply to get something in return from the organization or the individual is using data protection laws to harass the organization. The adjective manifestly used in the GDPR means that the request must be explicit or excessive or unfounded. The burden to demonstrate that the demand is manifestly excessive or unfounded rests on the controller's shoulders. It would be a better option to open a dialogue with the data subject than refusing to act on the request. A request may seem excessive or unfounded simply because it is not correctly formulated or the data subject does not fully understand her/his rights. Controllers may ask for additional details, for example, to help find the requested information. A refusal to act should be kept for extreme cases to ensure that the controller does not expose herself/himself to sanctions. Every request should be answered free of charge, Article 12(5), and Recital 59. A reasonable fee, based on the administrative costs necessary to provide the answer, may be imposed only when the demand is deemed excessive. A data subject's request will not be considered as extreme if S/he wants to receive additional copies of information already provided, but a fee can be charged in these circumstances. The data subject should be informed about the amount payable, and the controller has the right to wait until the payment is cleared before providing the information. If the controller has a reasonable doubt about the identity of the person making the request, S/he may require additional information to confirm that S/he is replying to the right person. The requested information should be proportionate to complete the identification of the person, and not go beyond what is necessary to do so.